And we're sitting on the cashier's couch here.
I know we should all bring a token from home.
I
Okay,
know.
what was in the picture? Bring it.
I know. That was different, that whole series of Zoom from home. You could put it on pause and get a cup of coffee.
Yeah, right.
Yeah.
I don't want to hear what you're saying.
Right.
Video.
One thing I have to tell them that someone's taking a bathroom break and said their name or their icon showed up.
Yeah.
How you doing, Ralph?
No, that's too bad. That's great.
Thank you.
Finally made it back to the gym. It took me about a dozen tries, but I finally could make my padlock combination work again. I remembered the three numbers. I couldn't remember the sequence.
Are you ready over there, Jen?
Can you hear me, Carl? I can hear you. Okay, let's do it just now.
All right, I'm going to call the meeting to order. It's 7 o'clock. Mr. Secretary, if you'd be so kind to do the roll call, please.
Yes, sir. Mr. Chair, Dean Hill.
Here.
Joe Marinaccio. Here. Susan Peck.
Here.
Doug Stebbins.
Present.
This is Andy Rocket. I'm here. Dan Thayer. Ralph Williams.
Here.
And B.J. Farrow. Not here.
Thank you. Would you also do us a favor and read the legal notice into the public record?
Yes, sir. Number ZBA 21 TAC 003, Mary and David Thomas Summers, appealing the approval and issuance of a zoning permit for Matthew Moylan to construct a 2,400 square foot accessory structure at 119 George Wood Road, Summers, by Jennifer Roy, zoning enforcement officer for the town of Summers.
Okay, before we get going, I just want to let you know that Carl Landolina is with us. He's on the speakerphone.
You want to all see them again?
Yeah. Hello, Carl.
That's his best side. Which alternate do you want serving?
Oh, Ralph, we're going to have you go this time. Susan was serving last time
Not all.
as the voting.
Oh, yeah.
Before we get started, I did receive some correspondence from Thomas and Radina D. Filippi of 128 George Wood Road in support of the Moylans and letting them build the house and the accessory structure. All right, so I guess we can get started here and have Mary and David Thomas give their presentation.
Take my mask off. Do you guys want copies of what I'm going to say? Because I have copies.
Sure.
I only have 5. I think there's 2 there.
Doug and I.
Is there any, Dean?
There you go.
Thank you, sir. Notice like the butters and anything that has to be on this type of thing.
I just sent them last week just because of formality.
Thank you.
Okay.
All right.
This is in response to Attorney Landolina's legal opinion. When he was asked how tall the building could be, he said based on Section 214.38, it could be as tall as the main building, which would be 35 feet. If, in fact, you call it a garage. So this is my answer to him. His actual legal answer to us was, it applies, 214.38 applies solely to barns, stables, and garages. It's specific as to those types of buildings. He said 214.98 applies to all accessory buildings that are not barns, stables, or garages. And under Connecticut law, specific language and zoning regulations always takes precedence. Since 214.38 is specific and 214.98 is general, 214.38 would apply to garages as long as the building in question fits the definition of garage in the regulations. Well, 214.38 says on C, a barn, stable, or garage may be erected to the same limits. D of the same section says accessory buildings on a residential lot may include private garages, in which not more than one space may be occupied by a commercial vehicle. 21498 limits all accessory buildings to the height of 20 feet. There's no definition in the regulations for garage. There is only a definition for private garage. A private garage is a building or part thereof accessory to a primary building, providing for the storage of motor vehicles and personal property belonging to the occupants of the home. There's only one definition of a private garage, and as Attorney Landolina said, the garage must meet the definition of garage in the regulations. Mr. Moylan has an approved, yet to be built, 2.5-car private garage on his site, along with his 1,800 square foot home. So he already has one on his site. The building in question is 2,400 square feet with a footprint of 40 by 60 and is planned to be 32 feet tall with a 14 by 16 foot garage door. To give you a visual of how big that really is, from my vantage point, you could park 4 fire engines side by side with their equipment and then have room for 4 on top of that and 4 on top of that. It is larger than any building in the residential area. Definition of personal property from the town charter says property which is owned, utilized, and maintained by an individual or members of his or her residence and acquired in the normal course of living and maintaining a residence. The term personal property shall not include merchandise which was purchased for resale or obtained on consignment. What personal property of a residential homeowner is 32 feet high? The zoning officer signed off on this accessory building that was presumed to be 20 feet tall, which is what the building regulations state. I do not believe she would have signed off on it and approved it if she knew the building was 20 feet higher and was 30 feet. Nowhere on the building plans did it give a 30-foot measurement, no height measurement of the roof. The plan clearly lacked the necessary information and was deceivingly unclear that was presented. Mr. Moylan owns a party supply company and equipment rental business, and this proposed windowless accessory building with a separate office space would be conducive to storing these items and conducting his business. Mr. Moylan is also constructing, according to his site plan, a separate driveway that gives exclusive access and egress to this accessory building. A standard garage door opening on the side of the building, which was not noted in the original plans, and would thereby allow vehicle traffic in the setback of neighboring property, be it mine and other neighbors. Also in the zoning regulations, an accessory building or structure is a supplemental building or structure, the use of which is subordinate and incidental to that of the principal building or structures, and which is located on the same lot or a contiguous lot. The footprint of Mr. Moylan's accessory building is significantly larger and taller than his permitted ranch-style home, and larger and taller than every home surrounding it and their garages. So I don't think it's subordinate or incidental. I do believe that this building meets the definition of a private garage. I do not believe. But rather only the definition of an accessory building, and per the regulations should be lowered to 20 feet, as allowed by the building plan, and is now in violation of section 21498 by 12.5 feet. If it would be considered a commercial garage, section 21438 would apply, but it wouldn't apply to be constructed in a residential lot, in a residential neighborhood.
Okay. Anything else? Any questions from the board? Go ahead.
So the basic brass tacks issue is the building's too big.
Correct.
Tall.
It's
Too tall.
it's
Too tall is the-
32 feet tall. I have a 3-story house that's 31 feet tall.
Mm-hmm.
I just don't understand the concept of an accessory building that large.
Okay.
And he's got it at his back border, which is my border, to its limit,
Mm-hmm.
and to the neighbors on the other side, and to the neighbors on the other side. Because it's an odd-shaped lot. It's a square with a little square behind it, and he's got it in the square behind it. And when I asked him why he pushed it so far back, he said he didn't want it that close to his house.
Is this the building that's already under construction on Georgia Road?
Yes. It's huge. It's unsightly.
Who's this?
Go ahead.
Can I be allowed to ask Jennifer a question?
Absolutely.
Okay. Jennifer, I just want to make sure I'm on the understanding of what happened in your end of it, because this is an appeal to what you signed off on as a
I will check
zoning.
with Carl and Lena as to the order of questions and how to,
Yeah.
I'm not,
Okay.
Carl, in the order of the questions here, the appeals are a little bit different. So should, I'm thinking maybe Ms. Thomas gave her presentation. Should we take comments from the rest of the audience first and then go to Jen?
That's entirely up to you, Mr. Chairman. I assume that the appellant, Mary Thomas, is finished with her presentation?
Yes.
Does any of the board have any more questions of her?
I don't think so. I mean, we're still in
Not
the
right
questioning
now.
period, so we could go back.
Yeah, we could go back, but not at this time.
I actually, before we change, let's say, witnesses, I have some questions of Ms. Thomas, if I may.
Certainly, go
Sure.
ahead.
Okay. Mary, how are you?
I'm fine, how are you?
Good. I have other questions too. So, when did you first learn that the building was going to be, or when did you first learn that the zoning enforcement officer had issued a zoning opinion that allowed the building to go forward? I assume you know that she signed off on the building permit.
I do know that, yes.
Yeah. So when did you first learn of that?
I think it was after the top rows of plywood. I saw the foundation from my backyard, and then when I saw the walls going up, I called to find out what size this building was going to be. Actually, I'm sorry, I went in and I spoke with Jen, but before that I had gotten a copy the day before, Jen wasn't in, of the building permit and the site plan. And the building permit says garage storage, but the site plan was the building plan was very unclear. It showed 20 feet on it, it never showed the roof right, so it was very confusing, and I honestly think that Jen was surprised that it was as tall, because that was not her understanding of it, or I can't speak for, all I know is that it was very unclear how the building was, so I wanted to know how big it was going to be. Then I checked the regulations, and the regulations stated 20 feet.
Do you recall when that was?
Hey, Carl, can I interrupt for a second? Is this leading to the fact that maybe she didn't file her appeal in time or something like that?
Yes.
Okay, so spill it. I mean,
How would
she's-
I know when he was doing it, what his intentions were, until I saw it?
No, well, I'm trying to figure out when it is you saw it. But I want to find out what you knew along the way, so.
As soon as I saw it and realized its size,
It has jurisdiction, so, you went in to see Jen, when was that? You know?
I don't have it written down here with me, I apologize, Jen, I had sent Jen the information, I believe she has it, right?
all right, give me a minute, please.
I can ask Jen that later. Did you, so you don't know the date, Mary?
It was the beginning of
Did you
April.
follow up with an email to Jen?
Mid-April.
It was the beginning of April, maybe 15th, 14th,
Which date, or which month?
April, I think?
She called on
Okay.
April, Jennifer Roy for the record, Carl, she called the office on the 14th and came in on the 15th. I was out on the 15th. She returned to visit me on April 16th. So within the
Okay.
14th, 15th, 16th was when she obtained copies of the permit and the plans.
Okay, and when did, and what was up then, Mary? Just
The foundation,
foundations of
the
walls?
foundation was in and some of the plywood walls.
Okay.
But
When
that's
did you
pretty much what's
discover
up there
that
now.
it was proposed to be higher than 20 feet? Or was
It's
gonna be
20
higher
feet, it's 20 feet now, and he's proposed to put 12 more feet on it.
So, I'm sorry, so the walls are 20 feet high now?
Correct,
Okay, and he stopped construction?
correct.
Okay. So there's no roof on the building now? It's just shored up,
Correct.
the walls are shored up?
There's no roof.
Okay, all right. Thank you, that's all I had. Thank you.
Okay. Do we have any comment from anybody else in the audience?
I have a comment. I live
Can you give
in
name and address, please?
Jody Cox, 28 White Birch Circle.
Thank
I
you.
walk past that house every day when I walk. And my concern is that if you allow a house that large in a residential neighborhood, that more could be potentially allowed. It looks like a commercial building.
It's not a house, I'm saying.
No, but it's a
Structure.
big building. It's a commercial, it
Yeah.
looks like a commercial structure. And we live in a very nice residential area, and I'd like to keep it as a residential area. It's obviously way bigger than anything else in the entire neighborhood.
Okay. Anybody else?
I'm just here representing Ryan Smith, who's his neighbor.
Okay. Your name and address, please.
Neighbor?
Name and
Ed
address.
Moylan, 19 Fulton Road, Somerville.
Thank you.
Ryan Smith said he'll write something up if you want. He said he has no problem with the structure. He said it looks a lot better than the current house that was there years ago.
Okay.
Mr. Chair, Attorney John Bond from the firm of Cummings and Lanza, here representing Mr. Moylan. Carl, I just wasn't sure what you wanted to do as far as the process. If I had any questions of each person that speaks, I don't know if you want me to wait or ask as we go.
Actually, if you have any questions, now would be the time.
All right. Okay. Okay. First is, I guess, a comment. Ms. Thomas as well as Ms. Cox both said that it was way bigger than anything that falls within that neighborhood. Ms. Thomas, I think you said your house was 31 feet?
Yeah,
The structure is 32 feet?
correct.
Granted, it's not a house, but it's not way bigger than anything else that is within that.
It's way bigger than an accessory building.
So who cares?
Any
That's
accessory
not,
building.
Right.
that's not the issue at hand. The issue at hand is about the zoning regs.
Right.
Not whether she says it's bigger than anything else or not.
So I can't comment on,
Who cares about that? The issue is, does it violate
Well,
the zoning
all right.
regs or not?
Carl had asked about when it was that Mary first knew. Just to kind of map out a timeline of folks didn't know. Mr. Moylan started to clear this lot back in October of last year. The topsoil was stripped February of this year. March 1st, the foundation was dug. March 17th, the foundation was completed. The walls were framed March 24th. The walls were completed April 12th. Question for Mr. Roberts. Did you have the occasion to visit the carpenter on site?
Who's Mr. Roberts?
Excuse me, Mr. Thomas.
Yes,
Okay, and that, do you recall what date that was?
I do not.
Okay. Do you recall what the status of the work was at that point? Were the walls up, was the foundation in, or about where did things fall?
Well, we weren't discussing the building so much as our dogs. So,
Okay,
but I believe either the walls are up or mostly up.
okay. We believe that date was when the walls were framed, shortly after the foundation being done. The foundation was done, correct? Or if you remember.
So it had to be walls are on.
All right. So,
Attorney Baum?
Yes.
If I can interrupt.
Yeah, where are we
Does this
going
go
with this?
to the issue of a non-timely
it
appeal?
absolutely does, yes,
Then-
it does.
Can you tell us what your position is with
My-
respect to that?
My position is that when considering the timeliness, if the town does not have its own specific time frame, then it defers back to state statute section 8, 7, which is a 30-day from the earliest of receipt of that order, the publication, or when the person had actual notice or they had constructive notice.
Okay, fair enough.
So I laid out the time
Right.
frame because activity started back in October.
Right?
And we believe that Mr. Thomas was there somewhere second or third week of March.
Of April.
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 Now,
Right.
it wasn't framed in March.
Can I explain? He just said that they finished building the walls in April 12th or 13th. He just said it. And I was there on April 14th. I was there as soon as I saw how high the building was. I can't see the ground. I can't focus on how large the building is going to be. But once it was up, it was up. And that's my notice.
And you gave the date of April 12th.
But once you saw that the foundation was in, you can't determine what height it is,
Correct.
Correct.
okay? But you obviously knew that there was some sort of permit that was issued, correct?
You didn't know then until you checked.
Well,
Well, it's like there's no permit facing our yard. But
no, but if there's a 40 by 60 footprint foundation and you had a concern about what was going to be built, wouldn't it have been prudent to check with zoning to see what?
we weren't objecting to the width.
Okay, let's reel this back in
Yeah.
here. Where are we going with this? Do we have some specific dates or proof that a timeline wasn't met? Because we're not going to be arguing this back and forth all night long, because there's other issues we also have to deal with here.
On the first day that the carpenter was there putting a sill on the foundation, that Mr. Thomas came over and consulted with him, what's going on over here? They had discussion up at the house, it's great, but he
Excuse me,
clearly
Mr.
knew that
Chairman?
there was.
Yeah,
Make sure that everyone identifies
yeah,
themselves.
I'm sorry, yeah, I need your name and
Matthew
address,
Boyle,
I'm sorry.
the
The court
owner of
will know.
119 George Way.
Okay, thank you.
So he clearly knew that what was going on, and the walls were framed out on the ground, and they were clearly 16-foot timbers. The walls sat on the ground for a couple weeks.
How would you know that?
Like,
Well,
Go
let me,
ahead.
can I, Carl, wouldn't any timelines be, it wouldn't be from when it starts, would it? It would be from when a permit is issued, wouldn't it be? On all dates from when paperwork is submitted?
So the issue here is the height of the building and whether it conforms. So,
Well, that's one of the issues, but that's not the issue we seem to be discussing now. It seems to be a timeline for an appeal.
I would think that the question is, and I think Mr. Bond might have misspoken, but it's a 15-day appeal period in Summers. So the question is, since the appellant, who is Miss Thomas, right? Are they both names, husband and wife, on the
Yes.
application?
Yes.
Okay. So the question is, when did the Thomas family know that the building was going to be 35 feet in height?
when you said it could be. That's
So,
when.
the foundation going in means they knew that a building permit had been issued for something. And then walls started going up. And as I understand Ms. Thomas's testimony, he then went into the building department
Correct.
to review a plan, which I apparently at that time showed a building of 20 feet in height. If I'm saying something that's incorrect, somebody I'm sure will correct me.
It showed 20 feet walls with a roof with no measurement.
Actually, I have the plan in front
Yeah,
of me.
no, I
Yes.
do too.
Yep.
Yeah.
So the question is, not when Ms. Thomas knew that the building was going to be 35 feet, but when did she know it was going to be taller than 20 feet?
When the walls went up.
And if you determined that that date when she knew had actual knowledge that the building was going to be higher than 20 feet, and therefore, in her opinion, violated 21498, if you start from that date and count 15 days forward, is, it was the appeal filed within that 15-day period.
Yes.
If it wasn't, then you have no jurisdiction to hear this matter. If it was filed within that 15 days, then you have jurisdiction. So it seemed to me the important question is, when did the Thomas family know that the building was going to be at least more than 20 feet high?
Well, I heard from the 12th to the 15th of April, and the appeal is received on the 26th, so it would definitely fall within that time frame.
Carl, it's John Bob.
Excuse me,
Yep, I'm sorry.
you'd like to speak?
Yes.
Okay,
Sure.
I'm the
Thank
chairman,
you.
not Carl.
I apologize.
Thank you. Go ahead.
Attorney Linda Lena, Attorney Bond speaking. Am I correct that the statute does not limit it to actual notice that would trigger that 15-day period, but also constructive notice?
That is accurate, but if you're going to argue that she had constructive notice, like a notice in the newspaper, or some other notice that's meant for the general public, then you'd have to present evidence that she had constructive notice. Constructive notice and knowing that something was going on are two different things. Knowing something is going on is actual notice. So I don't know, do you have evidence that she had constructive notice that the building might be higher than 20 feet prior to April 12th?
There's case law that would allow constructive notice consisting of observing site work, observing foundation building, observing walls being built, which would impart a duty to have that person determine what the ultimate fact is. What I'm saying is that there was site work being done, maybe not so much land clearing, but there was work on the foundation that began in March. So if there was any concern about what was being built, or if anything was being built, that site work would have been constructive notice to them that they, I don't want to say the obligation, but certainly the chance to go and see what was being built, how big, etc.
Attorney Bond, there's a huge difference between construction going on and the possibility that something might violate the zoning regs, right? Because a general citizen like me does not have constructive notice. If I see something being built, I could reasonably assume it's in compliance with the zoning regs. But what you're saying is I should have known, since construction going on, it may be higher than the building regs.
That is not what I'm saying.
It seems like it.
Well, then I'll see if I can be a bit more clear.
Make your words a little, smaller for me.
What I'm saying is, if we will say you because you, if you saw something being built,
right,
and you had any concern about what was going on, okay, that activity is noticed to you that if you're concerned, I might want to go and see what's going on. She did that. The initial plan that was filed, Mr. Moylan did not know specifically what pitch that roof was going to have. The building official advised him to, on his plan, denote the total height of the walls, which I believe is 16-foot timber, 4-foot foundation above grade. Okay? If somebody went in there and saw that with a 20-foot wall and some sort of roof on the top, it's absolutely clear that that structure is going to be greater in height than 20 feet.
Right. If I am a construction expert, I'd agree with you 100%. but
You
I'm
don't have
not.
to be a construction
And,
expert.
and if I see construction going on, which we see all around in our town,
Mhm.
I assume reasonably that it's going to be in compliance with the zoning regs.
Which
It
is
is
why-
not enough for me to assume, to say, oh my God, they might be violating it just because I see construction stuff. To go check. You know what I mean? And how is a reasonable person, the average person, me, Susan, Doug, to know that it's going to violate it just because there's 2x6 instead of 2x4 timber? How do I know?
But this point is not that minute. And your point about somebody sees site activity clearing a foundation, they assume that it complies with zoning. The town of Summers issued a permit. Everything that Mr. Moylan did complied with the permit that was issued to him.
Including the height of the building?
Yes. Subsequently, because that roof was not on there, supplemental plans got filed, and I believe that the total height is 32 feet, if I'm not correct.
So by yes in this case, you mean no?
I have no idea what you're saying.
Excuse me?
Yeah.
Do you have the paperwork that says that that was revised to be more than a 20-foot building, 20-foot tall building? Does somebody have that paperwork?
I do. Jennifer Roy for the record. I can give a brief description if the commission or the board would like me to.
Absolutely.
Yes, please.
I didn't know if we were still on establishing the timeline of validity of the appeal. Mr. Moylan put, when this came to my attention, Mr. Moylan discussed with me that he talked with the building official who told him to put on the building permit application that the height of the building was 20 feet. The plans that he submitted, as Attorney Bond mentioned, shows 16-foot wall, 4-foot foundation wall, and no clear indication of the pitch of the roof. So after discussing it with the building official, I asked Mr. Moylan to please submit a clear construction plan. Typically, I look at the site plan to make sure that it meets the required setbacks, 25 feet for an accessory structure, and that it's 20 feet high. When Mr. Moylan came to discuss the matter, he talked with the building official and myself. He then agreed to get a clearer plan, construction plan showing the height of the building to the peak of the roof. At that time, I had discussions with the building official who had concerns about the height of the building, and he thought it was strange, but he didn't bring it to my attention when we issued the permit in March. So clearly there's now, and I did receive on, and I'll submit it for the record, April 28th, Mr. Moylan did submit larger, clearer plans, which now reflect, if you scaled the original plan that the building official approved, it looked like it was about 30 feet high. Now this scale is a little more reasonable, and it says 32.5, I think. 32.6, 32 feet 6 inches for the height. So it's not clear. There's conflicting paperwork that was submitted originally and after the fact. And then as far as establishing if it's a garage, I did ask Mr. Moylan to provide me with a description of his use of the structure, just to maybe clarify for myself and the zoning board. And I will also submit his response. For the record, I received an email dated April 28th, informing me that his attorney had spoke with Attorney Landolina. Second paragraph says he does believe that his plans show all of the information I requested, which it did. And as far as his written response to his intended use of the garage, he plans to use the garage for any and all regulations that he is allowed to use it for under the zoning regulations. And then just questions me further about the stop work order, which is still in effect until we can clarify here or
with attorneys. So I'll submit the email and the plans for the record.
Any questions for Jen?
So I was led to believe this was all the information. I saw that you had signed off on the original building permit, so I guess that was it. That's what we were going on up until today. I was anyway, I didn't have any other information, so, which made sense to me. You signed off on it. The building inspector was the one that was watching what was going on with the building. You knew it was on the lot, right? So.
Jennifer Roy, for the record, you have the applicant's packet and information.
Yeah.
This is my supporting document
Right. Okay.
that I'm submitting tonight for the record
Right.
that I've
Okay.
gathered together as far as the issuance of the building and zoning permit and subsequent information that I requested from
Good.
the property owner. That's why I'm submitting it this evening.
Got it.
Any other questions? Go ahead.
Mr. Chairman, again, it's Attorney John Bond. Ms. Roy read that email, and we certainly don't dispute the content, but I want to clarify that Mr. Moylan's response was not intended to be disrespectful at all. But he shouldn't have to say specifically what he's going to use it for. Is he going to park his cars? Is he going to park a boat? Is he going to take up woodworking? Is he going to... It really doesn't matter specifically what. And if he were to commit to say that I'm going to use it for this, this, and this, that doesn't seem right that he should have to do that, so long as his uses conform to what the regulations require.
I concur with that.
So that response was not a flippant, I'll do whatever I want. It was more of partly upon advice of me to say, you really don't know. But the general concern is that Mr. Mullen is going to run a business out of it. He does have a business, as I'm sure most.
Well, I'd like to nip
okay.
this in the bud right here because that's, to me, I don't know if the board agrees, that's a whole separate issue. Okay,
The use
we're
of
here
the
to
building?
determine
Right.
about the structure.
Right.
It's not in our purview to,
Right.
Chairman,
you
can I
know,
say
if he
something?
if he, you know, chooses to build this 2,400 square foot building and do a commercial business out of it, you know,
That's absolutely.
that's against the zoning. The only thing I'll say is that's against the zoning regs, and
Which
you know,
Mr.
that's,
Mullen
you know,
absolutely
buyer beware.
is
So,
aware of.
that's a whole different issue.
Can I respond?
Yes.
Jennifer Roy, for the record, Attorney Bond, and respectfully to the zoning board, I didn't take that response as disrespect.
Oh,
I
good.
did take that response as vague, and I needed some additional information in order to determine, is this a garage? Is it a storage building? Is it accessory? You know, a garage typically stores, as it says, but so I needed additional information so that I can validate, okay, this is a garage and can be built to the same height limitations as the primary structure. Saying that someone's going to use something as the zoning regulations allow doesn't really provide any additional detail to confirm the vague description in our, you know, definitions of our thankfully replaced zoning regulations.
May I respond, Mr. Chairman? Just briefly.
Yes, briefly, please.
He is going to use it for storing personal property. He's going to use it to store vehicles. I can't possibly define what that personal property is going to be. I can tell you what he has now, I think. But in his application for the permit, he did check the box as far as what the permit was for. He did check other, and he checked garage. The permit was issued. The permit said scope of work. It said detached garage, outside storage, I believe.
Yeah.
So everything he's done thus far is consistent with him intending to use it as a garage, as that garage is actually defined within the reg. The other choice he had was to categorize it as a quote-unquote accessory building, which does have, the garage definition restricts any commercial use. Accessory building does not. Mr. Mullen went into this process knowing that whatever he builds, he cannot ever use it for commercial. So I just brought that up to show consistency, the understanding he has, and he absolutely knows that if it's ever used against the regs, then the penalties will be his to actually pay.
Matthew Moylan for the record. Just to clarify the communication with Building Inspector John Collins, when I filled out the application, I wasn't sure on the exact roof pitch. What was on it was a 6 pitch actually for the roof. It clearly showed that it was elevated above 20 feet. And he said that's not a problem. You know, when he figured it out, because I wanted to make it match the house with the trusses, it turns out to be a 7 pitch. So it's just climbing an extra inch per foot.
So regardless of the issue of when notice should have occurred or when the appeal was made, is your building as built in compliance?
Yes, sir.
You agree with that, Attorney Palm?
Based on the plans and based on the current zoning regs, yes, I do.
All right.
Well, that was my question too, but I wanted to hear it from either Carl or Jen if this building is in compliance. Because, you know, I'm still not sure whether it's an accessory structure or a garage. I haven't heard definitively what exactly this building is.
Right.
And I'm not going to be voting on anything until I at least know that.
So, for the record, Carl Andolina, so, I can't tell you whether it's a garage or an accessory building. Unfortunately or fortunately, that's the quandary or question that you need to answer. I can tell you that if it is a garage, and it's allowed to be 35 feet in height. If it's not a garage, a stable, or a barn, then the max is 25 feet. It becomes an accessory structure. So then the next question, I guess, for you to ponder is, there is a definition, I guess, of private garage in your zoning regulations. So that's been stated to you as to what that is. And maybe, Jen, you can read that again. So,
What was he asking to read?
The definition of a
the
private
definition of
garage.
garage, and does it say garage private?
Yeah, it's in your packet. Is that what Mary wrote?
Mary had
Were
one,
you the
yeah.
one that said that
Yeah.
definition?
You want it? Want me to read it?
Like a building or part thereof accessory to a primary building providing for the storage of motor vehicles and personal property belonging to the occupants of the premises and in which no occupation or business for profit is carried on.
So, a garage is typically an accessory structure. All right? In your case, it is still an accessory structure to the primary structure being the house. But under the section of the regulations that talks about height, it's specific to allow garages to be as high as the building, whereas 21498 says I read it to mean essentially any other accessory structures other than garage, barns, or stables are limited to 20 feet. So the next question, I guess, for you to answer is, you determine the credibility of the witnesses, okay? You have a statement from the applicant in writing that says he's going to use the building for uses that are permitted under the regulations for garages, i.e. the storage of motor vehicles or personal belongings, personal property. I don't know that you have any evidence to contradict that. You have speculation that it could be used for other purposes. But if you find the statements of the property owner as credible, that in fact it's going to be used in a manner consistent with the definition of private garage, even though the section in the regulations which allows garages to be 35 feet high doesn't use the word private garage. Just, I think it would be reasonable to assume that that's what it's referring to, because other than private garages, there are only commercial garages, and those typically wouldn't be accessory uses, but primary uses in commercial zones. So, you're going to have to determine whether the evidence establishes that, in fact, this is intended to be a garage.
Okay, Mr. Chair? So it finally clarified in my mind. If they had said, I am going to use it as a private garage, it's okay, right? Big building, but whatever, as long as it's in a high pass, I'm fine. I don't think they said that, though. They said, in a manner consistent with zoning regs. You know what I mean? And that's too loose for me. It's just too loose.
Also, for me,
Go ahead.
also the fact that there is no house to attach it to at this point. We don't know if it is going to be the garage or the accessory building because we don't even have a house to put it next to. So it's just something else to think about.
Mr. Chairman, Ralph Williams for the record. The cover sheet for the building permit describes it as a detached garage / storage building.
Again, Attorney John Bond, once again, there's no intention to be vague as far as what this is going to be used for. It's going to be used consistent with the regulations. He's going to store his personal property. It's a private use. He's going to store vehicles. If he has a boat, he's going to store a boat. I don't know what you're looking for me to specifically say. It's going to be 100% personal use. There's no commercial activity. The commercial business he has, he is currently renting space on Field Road. He has the business space and he has his personal space. Okay? Again, we're not being vague. We're not hedging. This is going to be a personal use building. It is large. It's larger than any garage I've had. The question was is that we don't know whether it's truly going to be that accessory building, private garage, whatever. Your zoning regs, 21438J, reads, accessory buildings to a proposed main building may be erected on a then vacant residential lot, if so placed as to not interfere with the eventual practicable and conforming location of the principal building. So the regs allow this building to be built before the primary building, which would be his house, and I believe a permit was applied for the main house. So as things stand now, there's no question as to what that main building is going to be. It's going to be his home. It just so happens that he's building this other building first, but the regulations actually allow that. So I would like to think that the ultimate determination as to whether this is truly accessory or not is put to bed by the fact that there is this accessory building permit, but there's also one that has been granted, I think. Is that right?
What was that?
Whether the permit for the house has been granted.
Correct, both permits have been issued.
All right. So I think it answers whether this is truly accessory or not. It is, because there is going to be a home there.
So you're saying it's an accessory building?
Yeah.
Yes. And within the regs, accessory buildings can certainly can certainly include 21438D. Accessory buildings on a residential lot may include private garages in which not more than one space may be occupied by a commercial vehicle. My point there is that accessory buildings, residential lot, can certainly include that private garage. That private garage can be up to 30 to 35 feet, so long as it's used for the storage of vehicles, personal property. And with everything Mr. Moylan has done so far, he's always used the word garage. And that's what he intends to use this for.
Thank you. Any other question?
Hi, my name is Donna Richardson, and I live at 289 Fall Hill Road, right behind the building. Call me naive, whatever. There's one thing that I can't stand is lying. And my husband and I, have been trying to work with Matt. Matt, he told me he felt his building was safer for his equipment, for his things, rather than having them on Field Road. We have been trying to comply with him. Every time I look out there, this thing is monstrous. It looks like a drive-in theater. That's how big this is. And my husband didn't want me to say anything tonight, but I'm just thinking, what happens when we go to retire and I have this huge storage building behind my home that's not used for storage? It's used for his, what do you end up doing?
Yeah, but we can't, I understand what you're saying.
That's why it's so big.
My question here is only, is this building legal under the zoning regulations of
I
Summers?
understand that.
Okay, I can't, I understand what you're saying, but we can't get into, it's too big, I don't want this. Is it legal? That's the only thing that we can deal with, whether, somebody's not going to be happy or whatever.
But it's not being used for what you said, for a garage or a storage.
It's like I said before, if he uses it for something other than, a private garage or storage, then, buyer beware. That's, then he would be in violation of the zoning regs. But that's not for us to determine. That's not in our purview. The only thing we can determine is this a valid use? Correct?
Yep.
So, I just want to clarify something, Carl. I'm looking at the building permit application. This comes to what you were saying, Andy. And the purpose of the permit, it says new construction detached garage. So would that qualify it as, when he's putting that down on the permit, does that mean it's a garage?
That means that, for the record, Carl Andrews, that means that the building official and the zoning enforcement officer can rely on those statements in making their decision as to whether this complies. So the applicant has indicated it is a detached garage on the building permit, and based upon that, the zoning enforcement officer would then determine what height it can be based upon the zoning regulations. So now, if I don't know what else information is. He also said that the building was going to be, 20 feet high plus a pitched roof. Is that my understanding?
Correct.
Ben?
Yes.
Yes, Carl. I'm not sure if this is pertinent information or not. Jennifer, for the record, just to interject, if we're going over the actual permit application and what I believed to be the true and accurate information, it says height 20 feet. And I do believe, and I'm not trying to point any fingers, but I know that John Collins helped him complete his application, and that's actually John Collins' handwriting that says detached garage at the top of the application. I don't know if that matters. I just think there's a lot of inconsistent information.
Yes, the application does say 20
So
feet high.
is a valid permit when The application says one thing, the plans say another, and yet additional plans say a third thing, I'm not sure. at this
So
point
it's also,
what he's
well,
going to
it's my
construct.
understanding you just testified that the 20 feet was inserted by a town official?
No, the description at the top, to clarify, at the very top of the building permit application, has location of work, 119 Georgewood Road, purpose of permit, new construction, and then, there's a box for applicant and owner, and all of that was filled out by Mr. Moylan, including where he checked the box that says other and put garage, and then when he put the height, he put the dimensions, 40 by 60, 20 feet high. The word at the top, purpose of permit,
Yeah.
with additional wording, detached garage, that's John Collins adding to the description at the top. I'm not saying it was done after the fact. I'm saying he assisted Mr. Moylan in filling out the application. So it's just inconsistent as to what the building official and the applicant and the height.
Well, I guess, again, for the record, Carlene, the next important question would be, did you believe at that time that the maximum height, including the, as you define height in your zoning regulations, which is the average, the mean grade around the building to the highest point and the peak of the roof, did you believe that measurement was going to be 20 feet?
Yes, I did. And at that time, I believed that to be the accessory height structure limitation. Once I issued the stop work order, Mr. Moylan came right in and discussed with us, and he and John Collins discovered the section that says 21438, where a barn, stable, or garage, same height limitation.
And so up until that point, you were under the impression it was going to be 20 feet high.
Correct.
And do you know when you discovered that it was going to be higher than that?
On or about the same day, as I discussed further with John Collins, looked at the actual blueprint / construction plans, and to what that scale was, and that showed it to be 30 feet. And then later, a week later, I received the revised plan from Mr. Moylan that shows it to be 32.6.
Okay. So, and then, I guess my next question, and then you issued a stop work order until, why did you issue that, or when did you issue that?
I issued the stop work order when the complaint was received by Mrs. Thomas so that I could clarify what was actually being built and what the height was.
Okay. And so subsequent to that, you were informed by either Mr. Moreland and or John Collins that the building was going to be higher than 30 feet.
Correct. Both of them.
Both of them.
Right, in conversations. He came in and spoke with John Collins, spoke with me briefly. And it wasn't going well, so I let John talk to him about his plans.
So when the permit was issued, it was thought that the height was 20 feet.
That was my belief, with what was filled out on the application.
Do you have anything else, Carl?
No, I guess the ultimate question was, as you sit here today, based upon what you know at this point, do you believe that the building is in conformance with the zoning regulations as proposed as you know it now? I.e., it's going to be smaller, it's lower than, or not as high as 35 feet, which is the height in the zone, and is proposed to be a garage. Does that conform to the zoning regulations as you understand them?
What are our options here, Carl? As far as, because I'm struggling to wrap my arms around this one. I'm looking at the application and it's saying it's 20 feet high, and that's what the application was based upon. And I'm also seeing that, based upon the structure, it might actually meet zoning regulations. But what about, is an option maybe resubmitting the application?
Well, I suppose that is an option. Understand that may in fact re-trigger the appeal period, so that we might be doing this again in a month. But I guess I'm looking for Jen to say, because that question was directed at you, Jen. In other words, is this a private garage in your understanding? And if it is, our private garage is allowed to be in this particular zone 35 feet in height. And if that's the case, is, as far as you know, is the building proposed to be 35 feet or less?
Okay, Jennifer, for the record, I thought Dean was asking what the options were. I've stated, and I'll restate it, Carl, that my opinion is this is an accessory building, a storage building, and it should be 20 feet high. That's my opinion, and that's what I believed I was issuing a zoning permit for.
Okay.
Mr. Chair, are we still in the information gathering? Or
Yes,
in the
we are.
public? Oh, okay.
Okay. Any other questions?
Yeah, I got a question. Only one person will know what's being built and how high it's supposed to be. All right? Everybody's second guessing everything that's being said here. If it's in the zoning regulation, if it meets the requirement, it should go through. It's just kind of ridiculous. You're saying it's going to be used for a garage. Unless you can prove something other than that.
Easy.
No, I'm telling you, this is a joke.
Do you know how high the building is?
You said it was 32 feet or something like that, and he's saying it could be 35. So he's within the regulations. I don't know what the issue is. It's stupid.
Well, no, it's not.
Yeah, it is, because you're trying to second guess what he's making happen. You don't know what he's doing. He said it's going to be a garage.
We just got to go by the paperwork.
And okay, sounds like if he's in the regulations, he's in the regulations. If he's in the right height, it's the right height.
That's what we're just trying to.
Look, he just said 35 feet. I heard it 20 times. He says 32 feet. So 3 feet lower than what it's supposed to be.
I know it's frustrating.
No, it's a joke. This is a joke.
I'm never frustrated with town government.
Yeah, I know. I've seen you in action before. Come on, don't tell me.
But we got to watch. Got to go back.
I mean, I understand, but come on. He's within regulation. I don't understand what the big deal is. I really don't. I mean, they might not like it, but you know what? I don't like, across the street from me, I'm looking at solar panels on a house, but it's not my house. So I don't care, because that's his house, he owns it, so he can put whatever he wants on the house, across the street where I live. Mm-hmm. If you paint it purple, you paint it purple. Oh well, not my favorite color, but that's what it is. I understand her problem. She sees a big structure. But you know what? If he's in a regulation, he's in a regulation. You can't go over anything like that, because
So when he starts bringing his things in.
then you complain.
Okay, hang on.
That's like buying a house at the airport. You don't like planes going over it.
You've made your point.
You know what I mean? You buy a house at the airport, you're going to have planes going around it. Believe me.
Okay, thank you. Anything else? All right, last comment.
Yes, for the record, Attorney John Bond. Just a point of clarification with Jennifer, Ms. Rowland, sorry. The application, page 1, does say 20 feet. The application did have a plan attached, correct?
Correct.
As simple as the plan was. And I believe it
Building
should...
construction plans are reviewed by the building official.
Right. But the plan attached to the permit showed the 20-foot wall, and it did have a roof structure on it, correct? So, in looking at that plan, I don't think it would be accurate to say that somebody thought that the height would be 20 feet.
Jennifer Roy, for the record, as I stated to your client, generally, my practice is to look at the site plan for the setbacks and review the application for what the applicant states is the height of the structure and signs the application. The building official looks at the building plans for the construction of the walls, foundation, the trusses, and all of that information.
So the building permit was issued by the building official.
Correct.
Your part within that process
The zoning review.
okay. And as part of zoning review, would you normally look at any attached sketch? Because height is part of zoning.
I realize that it is. I review the application and I review the site plan.
Okay. So did you review that sketch that showed the 20 feet plus a roof?
I reviewed the sketches. I did not take an architectural scale. I'm not an engineer.
No, but it says,
Basically, my position is I reviewed the application that Mr. Moylan put 20 feet in for the building height. That's my position.
but that was the same application that the sketch was attached to that showed
And
the
the
20
building
feet.
plans were attached to for the building official, yes.
That showed the 20 feet plus a roof. Yeah, yes?
That's the application that was attached to building plans and site
Okay.
plan.
All right, thank you.
May I ask one question?
Yes, go ahead.
Mary Thomas. When I saw the walls go up, I called, first I stepped in and then I called and I did try to speak with the building inspector. He was very aggressive and rude and wouldn't answer any of my questions as to how big anything was going to be. All he said to me was, all I do is building. I know nothing about zoning. And he just kept repeating that until I finally hung up. I believe he knew, I want to say, I believe he knew that the building was too tall as far as what they had said they were applying for. And he got aggressive to me, and I said, well, you don't have to be aggressive to me. And then I called, and I talked to the GIS guy, the land use. I talked to Jen. I talked to the first selectman. So I did my due diligence to let everybody know that. And when I said something to Jen, I said the building is 30 feet tall. She said it is not. I said it is. Because the application said 20 feet tall, and she goes, where did you find that out? And I said, I looked at the plan and I measured it out. So she didn't know. It was not, she never signed off on a 30-foot building.
Can I have a motion to move from public hearing into public hearing discussion decision?
Make the motion.
Second. Any discussion? All in favor? Aye. Opposed? It's unanimous. Okay, we're in public hearing, discussion and decision. Any comments? Go ahead, Andy.
I have a motion. I move that we consider the appeal as timely filed and the building in violation of the Summers zoning regulations.
I'll second that.
Discussion.
The motion was that we consider the appeal as timely filed and the building in violation of Summers zoning regulations.
If I may, Mr. Chairman, so I think that, Mr. Rocket, so specifically you'd be finding that the issuance of the permit by the zoning enforcement officer, for whatever reason, should be overturned. In other words, she issued the permit. In other words, she signed off on the permit to build something. So you'd be essentially overturning the decision, which is fine. I just want you to be consistent. So you're finding that the issuance of the permit by the zoning enforcement officer, not the issuance, but the sign off on the permit, that she shouldn't have signed the issuance, she should not have signed off on the building.
I'm not saying that at all. I'm saying the building is in violation of Summers zoning regulations. That's what I'm
I know,
saying.
but in the context of what you're being, I'm not, being adversarial. I'm just trying to say, in the context of what you're being asked is whether the zoning enforcement officer should have signed the permit. Because if you find that she should have, then you have to sustain, or you see what I'm saying here? I'm not making myself clear.
Yeah, so I think the appellant's
proceeding is
I think that the appellant's motion was with respect poorly worded. You know, what she's saying is the building's too big, so I appeal. The zoning enforcement officer shouldn't have ruled that way. The zoning enforcement officer actually meant it to be 20 feet. There's substantial confusion as to what the use of the building is, and thus what height it could be. And because of that confusion, it was built too big. So all I'm saying is, what?
Change the word big.
Yeah, big, right.
Oh.
It was too tall. And so what I'm saying is, right now, that appeal was timely filed, and the building's too tall.
Right. Right. So you're agreeing with the appellant?
Yes.
Well, this is what I'm saying. Her appeal was timely filed, the building's too tall. That was my motion.
Yeah. Okay.
Can I speak? If you're agreeing with Mary and Mr. Thomas, you would be agreeing that they don't think that Jennifer issued the permit correctly. And I don't know. I think that Jennifer issued the permit correctly. She thought it was going to be 20 feet tall. She signed off on it way back in
Well, the issue.
on January 27th.
Yeah.
That was her
I'm not
original
clear on what
signature.
you're
Well-
trying to say.
Fact is, if she issued the permit on the understanding that it was going to be a 20-foot high structure,
Right.
when neither the applicant nor the building official ever intended it to be a 20-foot high structure, then she acted on inadequate, incomplete, or incorrect information. That is not necessarily reproach her except insofar as you want to argue diligence. She acted within her competence with the information provided, which turned out not to be accurate.
Right.
Right. I'm not, and again, for the record, I'm not saying that the building official did anything wrong here. What I'm saying is that in the context of this appeal, they're trying to get you to overturn the issuance of the building permit. That's all. That's what the context is. So just understand what Andy's saying would in fact be a de facto overturning of the building permit. So just understand what I'm saying.
What I'm saying
So,
is
yes, you're saying
the opposite.
that if you're agreeing with the appellant, then that's in fact what it is you're doing. No, through no fault of the building or the zoning enforcement officer, just as the facts arose as you understand them now and she understands them.
So since we're in discussion on the motion, what's your point there, Susan?
Okay, so this is an appeal
Right.
of
Jen's
Jennifer
granted,
signing
right.
the permit
Right.
on January 27th for a
Right.
20-foot high building.
Right. Right.
Well, I agree that Jennifer did the right thing on
Right.
January 27th. You're
Right.
saying that she didn't.
So what's the proposed in your mind? And I'm asking.
Mhm.
Resolution for a building that is too tall and thus in violation.
I don't think it's our decision to make. We're not the building inspector or we can't change that now.
Well-
It's not up to us to change how big that building is. We can't, that has to go back to the building inspector and the land use, I would think. But the decision that Jennifer made, was it right or wrong on January 27th when she signed it? That's what we're appealing here today. That's what they're appealing.
But since Jennifer's already told you that she was acting under the assumption that it was going to be 20 feet high, an accessory building, as she said, which is
Which
the
is
terminology used in 21498.
Mhm.
If indeed at no time did either the applicant or the building official intend for it to be that, then they were giving her erroneous information, and basically she was acting improvidently, and I won't say unwisely, but she was being misled. We are not obliged to leave in place an order that is based on misinformation.
I disagree with that. you had the building inspector, John Collins, that signed off on it, and he knew what the height was and what the right. We need to talk to him and find out.
We're the zoning board of
No,
appeals.
yeah, this is zoning board of appeals. We need to talk to John Collins and see, because he worked on it. He knew the roof is higher than 20 feet, and he signed off on it and gave him the permit, and now he's halfway through the building. Now you want to pull it out.
But that's not the zoning permit. right?
Respectfully, again, for the record, Carleen Lena, that is not the issue. The issue is whether or not Jennifer, okay, acted appropriately, all right, based upon the information that we have now by signing off on a building permit as a zoning official for a building which is described in some fashion as a detached garage. Jennifer believes it's now not that, but an accessory storage building, and therefore the height was limited to 20 feet.
Well, how come we don't?
You can't second guess what John Collins did.
No, I don't want to second guess. I want to talk to him.
What Jennifer did.
I want to talk to John Collins, and I want to see why, because he approved it. He's the one that signed off on it too. Well, there's another piece to the puzzle here.
Carl, if a zoning enforcement officer, Jen, signs off on something, and then subsequently someone builds something not in compliance with that, what is the remedy?
You don't issue a... So when the certificate of occupancy is going to be issued, when the building's complete, that Jen will have to sign off again, saying it conforms to the zoning regulations. So let's say this appeal didn't ever happen, okay? Mary Thomas and her husband didn't come forward, and the thing went to completion. When the building was going to be given a certificate of occupancy, Jen would have to sign off on that as well. And if she learned, prior to signing off on that the building was 12 feet or 13 feet higher than it should be under the zoning regulations, she would then refuse to sign off on the certificate of occupancy application.
Got it.
Any other discussion?
I think we're getting tied into some of this nuances that had happened here throughout this process, and it's probably not our purview. I think we need to vote on where we stand today on this. And you know, I would tend to believe that the way I look at it is, to Sue, your point, she approved the building the way it's supposed to be approved. And if Attorney Landolina is saying that certificate of occupancy is going to be the issue, then Matt, you're going to have some issues down the road, and that's going to be not on us to decide.
My whole problem with this thing is that permit was issued under the information given on the permit. From what I'm hearing tonight, you know, it sounds like this could possibly be a structure that meets zoning requirements, but it wasn't issued under those circumstances. So I'm going back to it. I think it should be resubmitted. So I don't know if I can support your motion, but
Yeah, I will probably withdraw my motion, because after talking to Carl, I would withdraw my motion. And what I'd move is that we do consider the appeal as timely filed, that we overrule that appeal, but we also direct the zoning enforcement officer not to sign the certificate of occupancy as the building is currently constructed.
Do we have that authority?
yeah, that would be my first question.
I don't know. Why not? Let someone sue.
I would say, for the record, again, Carleen, you do not have that authority. You can modify the terms of the cease and desist, but that's not what this is. So, if Jennifer refuses to sign off on the certificate of occupancy application, when that comes before her, I assume that this matter will then come before you again.
Right.
Because at that point, the owner of the property, I assume, will want to take an appeal of that decision and say, I'm entitled to a certificate of occupancy, and you'll have to decide at that point whether the building as constructed meets the zoning regulations.
Yeah, that's fair. I'm there. So then I would withdraw however many motions I've had,
There needs to be a motion on the
all
floor.
6 of them, and move that we consider the appeal as timely filed, and we overrule that appeal. That would be the end of it from our perspective. It would bump it back
I
to,
think our motion should state the grounds on which we overrule that appeal.
how so?
I was just going to say, but never mind. I mean, there should be something in the record indicating, why we do not think that it's worth granting, and we just said that it's time to file.
Mm. I'll let you make the motion, Ralph, if you want.
Well, can I step in again? Carl Andalina for the record. So the statutes and the law clearly state that when any zoning board, including the Zoning Board of Appeals, makes a decision, it shall state a reason for its decision. Now, the courts have said that that's not necessarily mandatory, and that if you fail to state a reason, the court will search the record to see if there's any substantial basis upon which the decision is within your purview and within your discretion. So you may have individual reasons why you might vote one way or the other, but I think what I'm hearing now is that one of the members would like you to discuss a collective reason for
I want to see if we
finding
can find
that the
find
permit
collective
was
reason.
appropriately issued. But I understand that's the motion. So
I want
that's
something more
up to
than
you whether
my
you do
vote.
that or not. So, Ralph might state why he believes he's voting in a certain way, and he might state why he's voting in a certain way. Dean might state something else, but that's entirely up to you as to whether you actually come to terms on a collective reason for the action that you're taking.
I have another question that might relate to you, Carl. With regard to the information that Jennifer was presenting to us tonight, additional information, she said she had other information about the building and the lot and the size and all that stuff. But that does that or does that not pertain to this appeal?
It absolutely does, yes.
Carl, what happens if we grant the appeal? What's the remedy for the applicant?
You mean for the homeowner?
Mm-hmm.
So the remedy would be to, I guess, lower the building to 20 feet or take an appeal of your decision to the Superior Court.
What about resubmitting the application? Is that a valid alternative? I don't think that's going anywhere on the board,
That would be
but
up to the applicant to decide. I don't think you can suggest that. That would be up to the applicant to decide to resubmit. This is a garage and it's going to be 32 feet high, and that conforms to the regulations. And Jennifer decide whether or not she believes that to be the case and issue a permit or not.
I think, Susan makes a good point, and Ralph makes a good point, and even the Black Prince makes a good point. So how about something like, we move to consider the appeal as timely filed. We overrule that appeal because though the building is not currently in compliance with the zoning regs, the application as submitted to the zoning enforcement officer was at the time of the submission in compliance. It was.
Sorry.
Yeah.
Well, I think that would probably be appropriate, given that even though right now the building is 20 feet high and it hasn't grown an inch since then, I don't know if you allow flat roofs on buildings. But in other words, so I think Andy's last motion there would probably be appropriate, at least to make, and then you can decide whether you want to vote that way or not. Keep in mind, it takes 4 affirmative votes to overturn the action of the zoning enforcement officer, which at this point is, in fact, signing off on the permit. That's the action that she took. Whether she would have taken it 3 months ago, knowing what she knows now, is not the question. The question is, she signed off on a permit, something's in construction, it's intended to be 35 feet high, and irrespective of what might happen down the road when she's asked to issue a zoning compliance for the certificate of occupancy, what's the status of that decision at this point?
So that'll be my motion. I'll withdraw my previous motions, and I move that we consider the appeal as timely filed. We overrule that appeal as though the building is not currently in compliance with the zoning regs. The application as submitted to the ZEO was at the time of the submission in compliance. That's my motion.
I'll reluctantly second.
Discussion?
No, I think you got it, Andy. I think that's what it is.
And that satisfies me to be at least stated the reason.
Right.
Yeah. All in favor?
Collectively. Aye.
All right.
Aye. Opposed? Abstained? It's unanimous.
So, I'm sorry, just so I'm clear, I thought I heard 3 ayes.
No, there's 1, 2, 3, 4,
I
5.
was quiet, I was behind the
it's fine,
screen.
unanimous? Okay.
Don't go anywhere, Andy.
Turns for their duel.
All right, folks.
All right, Carl, I guess we're all set for review. I appreciate your help.
No problem.
All right, you have a good night. Thanks.
I'll meet you over.
Yeah.
What'd you agree on, swords or pistols?
I'm sorry?
What'd you agree on, swords or pistols?
No, I said let's go for a beer. So he's going to meet me at the Villa for a beer. You know, it's a small town. We got to,
Comment? Dan Madden, 25 Turnpike Road. It comes down to the definition of garage versus accessory building. Isn't that really what we're breaking this down by?
Dan, you should have had this 45 minutes ago.
Yeah, I know, you're a little late.
Yeah.
Because even under accessory building, garages are still part of that.
Amend the application.
Very, very confusing and vague is meaning. And I believe it meets legal requirements.
Okay. All right.
I think that's what we just said.
Yeah,
Just in a different
I
way.
think you're walking into that tonight.
Okay, so let's move on. Correspondence, anything, Mr. Secretary, to you?
No, sir.
All right, no correspondence. We have minutes approval for March 2nd. Any additions, corrections, deletions?
Second.
Excuse me, Dean.
Awful short minutes for an awful long meeting.
When you're voting for the minutes, because I believe that when Matthew and I were creating the agenda, we might have the wrong date of the minutes. You might need to make a motion to correct. The actual written minutes are right, the agenda might state the wrong date of your 2 meetings in March.
Okay.
Really?
Yep. We had 3 meetings in March.
I have copies of the minutes.
There was one week we met twice.
It's new.
Yeah, and I think I missed the meetings for
You had
March
3,
6th.
Right, you had 3, one meeting minutes are missing.
March
Yeah,
9th?
March 6th, I thought. Maybe.
We're missing March 9th, that's when we actually dealt with another application.
Right.
March
Right.
11th,
So what's on your agenda?
no, where was it? March
Oh, okay.
It's a second.
All right.
You guys, I think, oh, Dean's
March
got all
16th.
copies.
March 16th. Oh,
Let's
no, these
see.
are the right dates.
No.
Okay,
I'm
the
saying
2nd and the
before that.
16th is what we have.
Right,
Is
and the
Carl
9th
on?
was a separate. Right.
So on the agenda.
So second and 9.
Second and 9,
Yeah.
but you have the second and the 16th.
Oh,
So I
okay,
would make
all
a
right.
motion to
Okay,
correct
gotcha.
the
All right,
minutes
I
and
get
then
you
we'll.
now. May I please have a motion to change the minutes approval from March 2nd and 9th, 2021 to March 2nd and 16th,
So moved.
That's for
2021?
the agenda purpose.
Second.
Second?
Second.
All in favor?
Aye.
Aye. Opposed? None. It's unanimous. Okay. Do I have a motion to approve the March 2nd minutes? Well, we already have that, so that we're good there. So any additions, corrections, deletions, etc.?
No.
All in favor? Aye. Opposed?
My pen ran out.
Oh. It's the minutes unanimous approval for March 2nd. Do I have a motion to approve the minutes for the March 16th meeting?
So moved.
I second.
Any additions, corrections, deletions, additions? I take that to none. All in favor?
All right.
Aye.
Aye.
Opposed? It's unanimous. Do I have a motion for adjournment?
So moved.
Second, Ralph. All in favor?
All right.
Aye.
Opposed? That's unanimous. We adjourn at 8:29.
So, you didn't say Dan's name tonight.
Dan?